Okay, good evening, everybody. My name is Janice Strutt. I am the co-founder and executive director of Morgan's Caring Connection, a local nonprofit that provides resources, education, and we aim to award grants to families in order for them to pay the legal fees in the case when they can't. But we do help support families regardless, help get connected with the right professionals to help navigate the struggles and challenges that we have as parents for special needs dependents. This evening, thank you for joining us. We have Dera Johnsen-Tracy, who is an estate planning attorney for special needs, as well as not for special needs, with Horn and Johnson. And she's going to talk about guardianship in Wisconsin, what that looks like, potential alternatives, so on and so forth. So I will go ahead and hand this over to her. I do have everybody muted. And then at the end, we'll leave this open for questions. So without further ado, this is Dera Johnsen-Tracy.
All right, let's see. I'm going to try here to. Mhm. What can you see? Can you see my screen and can you see, let's see.
You see the whole thing.
Can you see the whole thing? Yeah, along with the side. How? Oh, okay. Come on. All right. Let's see. Well, it may need to be the whole thing because, okay, continue to share. Nope, that's the same thing. Okay. Right here. Okay, is that
There we
good
go.
now?
We're good.
Okay, you can see the whole screen. Everybody can see everything okay?
Yep.
All right. Okay, so today we're going to talk about guardianship in Wisconsin, specifically geared towards parents who have children with special needs. So, just a brief introduction to myself here. I am Dera Johnsen-Tracy of Horn and Johnson, and I am an estate planning attorney. My office is over on the far west side of Madison, off of Old Sauk Road. And I'll just give you a brief lowdown of how I came to where I am today. I started working in law firms in 1994 as a paralegal, realized that I really had a passion for estate planning. I moved to Madison in 1998 and I went to work for an estate planning firm, which confirmed that this is what I want to do. There was a 10-year stretch where I worked full time during the day as a paralegal. I went to school at night, but by the time I graduated from Marquette Law School in 2008, I had 14 years of experience as a paralegal, and I knew exactly what I wanted to do. So at this point, my law partner and I, we solely focus, we're a boutique firm, we focus on estate planning, probate, and adult guardianship. So we have a passion for special needs. We have for a long time. My husband owns Superhero Martial Arts, which is a martial arts academy that works exclusively with children and young adults with various disabilities. So we've been actively involved in this community for a very long time. And I want to shout out to Janice. Thank you for bringing us in and allowing us to be part of your wonderful organization here. And so guardianship, I know, can be a bit confusing, right? And of course, there are so many decisions that have to be made, which we're going to talk about once your child is about to become an adult, technically, right? When your child is going to turn 18. Do you need guardianship? Are there other alternatives? What does it look like if we obtain guardianship? So we're going to go through the basics. And please forgive me if I'm getting very basic here, but I'm just going to start from the beginning. So those of you, I'm sure you probably know some of this, but we're going to start here. So let's start with what is guardianship? It's a legal process through the court, and that's where a court is going to appoint someone who is the guardian, or often if you have both parents who have been involved from the beginning, co-guardians, and we can appoint parents as co-guardians so that either one can help your child, whether it's a doctor's appointment or setting up an account or whatever it is. But those people are appointed to make decisions for another person, which is your child, who would be referred to as the ward when we're talking about legal terminology. It's typically considered when someone turns 18 and if they're unable to make certain decisions independently. Whenever we go to court in a guardianship proceeding, whether or not a person can make certain decisions independently is decided through what we call clear and convincing evidence. And we're going to talk more in just a moment about what that means and what the court is looking for. So when is guardianship needed? Well, if the individual, so the proposed ward has some sort of an impairment, a developmental disability, mental illness. And this, of course, we're talking about 18-year-olds today and other young adults, but this also applies to elderly people. If you have Alzheimer's or dementia, there may come a point where that person needs a guardian in the same way that an 18-year-old might need a guardian. So it's needed when that person cannot make or communicate decisions, or when they can't meet their essential needs for health, safety, or if they can't manage their finances. And there is no less restrictive alternatives, right? There are no less restrictive alternatives that are going to be sufficient to protect that individual. And that is important because we want to maintain independence for your child as much as possible when we're looking at the options that are available, while also making sure they have the protection legally that they need. So in Wisconsin, there are two primary types of guardianship. There's a guardian of the person, which we'll talk about in a moment, and a guardian of the estate. And they're two completely separate roles. Now, often we appoint somebody as the guardian of both the person and the estate. And that's referred to sometimes as plenary guardianship. You might see that when you're reading materials or doing research online. That's when you're guardian of the person and the estate. So, when you become the guardian of the person, the focus there is on the personal care and well being of that individual. So, if you're the guardian of the person, you're responsible for making medical decisions for that person, living arrangements. Are they still going to be living at home? Are they going to live more independently in some sort of a group home? You're going to help that person to establish the services and supports personally that they may be able to receive, and of course, to assist them with their daily personal care decisions. And so your main goals here are to ensure the health and safety of the individual, to arrange for services and care. And note that that doesn't necessarily mean that you are personally providing all of those services. Especially here in Dane County, there are a number of services that are available to assist, especially if your child chooses to live independently. But obviously, as the guardian of the person, you'll be required to visit and monitor them to make sure that they're being taken care of. And whenever you are appointed as the guardian of the person, you have to file an annual report with the court. It's pretty simple. You can find the form online. And it just says, okay, is the person still living in the same location they were living in last year? How are they doing? It's just a report to the court to make sure that you're checking in and that everybody's being taken care of. And you always want to use the least restrictive options when you're looking at their living environment. And of course, and you guys know this as parents, you want to honor the person's preferences whenever possible. Now, guardian of the estate, which is the other side of this coin, is different. This is the focus. The focus is financial decisions. So, for example, once your child with disabilities turns 18, as I'm sure you're aware, you're going to want to look at getting them qualified for things like SSI, right, and other benefits that they might be entitled to financially. And then when you help them set up the SSI benefits, once they're qualified, then you have to open a bank account, right, for them. And you'll have to make sure if that individual, your child is on SSI, that you keep that account under $2,000, right? Because in order to continue to qualify for SSI as an adult, you can never have more than $2,000 in assets. And there are solutions for that. So, for example, sometimes it takes a while, especially right now, to get qualified for SSI. So once you submit the application, which you can't, right away, you can't until the person is able to qualify until they're 18. It might be 10 months before they actually receive the qualification and they start receiving money into the account. So now you have $10,000 in back pay or whatever it is. And you need to protect those assets because once you deposit the money gets deposited into the account, they're already over that $2,000. There are certainly options that are available for that, whether it's a WISPAC trust or a private special needs trust. And that's, of course, more detailed. That's a topic for a different presentation. That's in the estate planning portion of the programs that Janice is providing. But you then, as the guardian of the estate, that's something that you would be required to do, is to assist to make sure that person continues to stay qualified for their benefits. And filing an annual account with the court is sometimes required, although I will say often, especially when you have a child with disabilities who doesn't have any assets in the beginning, the court often waives that requirement because the court understands that it's just a matter of keeping them under that $2,000, but not always. And it does also depend on the county. So Dane County tends to be more relaxed with those things, but if you're in some of the smaller counties, they will always require that accounting. And it is extensive, so you have to account on that form for every penny that comes into the account, every penny that goes out of the account, what it's for, what's left over, etc. So just be aware, whoever is appointed as guardian of the estate or standby guardian, in case you can't do it any longer, which we'll talk about later, that person needs to have the skills to make sure they account for everything. And so the court may appoint a guardian of the estate if the individual is unable to manage their financial affairs or is at risk of losing property or financial exploitation. And so there was a guardianship that I handled a number of years ago, and I had a client. She was raising her granddaughter, and you would never know that her granddaughter had special needs. You wouldn't know by looking at her, by talking to her, lovely young lady. But because she did have some disabilities, there was a very real concern that people would take advantage of her and that she would enter into certain types of financial agreements, contracts. Somebody might try to scam her, and her doctors confirmed that this was a very legitimate concern. And she was also unable to support herself independently. And so, again, even though you wouldn't know on the outside, she needed a guardian for her own protection. So, things like that, some of the subtleties here that you might not consider, those are the things that the court is looking at. So just to summarize the key differences between the two types of guardians: for the guardian of the person, you're responsible for the health and daily life decisions of the individual, for their living arrangements, for their medical care, and for arranging the services and supports that they might be entitled to and that they might need, compared to the guardian of the estate, which is all about financial decisions, managing their income and assets, paying their bills, and again, preventing financial exploitation. So when you're considering your standby guardians, if something happens to you, you want to make sure on either side that everyone's in the right seat on the bus, right? That's what it's always about, to make sure we have the person who has the skills to do the job. And I do want to talk about the least restrictive means, because especially in Wisconsin, the courts are very clear that we don't want to over-regulate someone. We want them to have the freedom, if they're able, to take care of themselves, to make their own decisions. So there's a form which we're going to talk about. It's the examining physician's report, and then that ties very closely to the final order that would be issued. And there are a whole list of things in that examining physician's report. So while your child's physician is doing a report, maybe they have the right to get married. They don't need permission. Maybe they have the right to get a fishing license. Maybe they have the right to do certain things, but they don't have the ability to do other things, right? And so again, there's a whole list, and I would encourage all of you to take a look at that examining physician's report, which I have a link to once we get to that section. So let's talk about the guardianship process in Wisconsin and what that looks like from a practical standpoint. So I always like to start with that examining physicians or psychologist report that we talked about. And again, I would encourage all of you to pull up this form when you have a chance, if you haven't seen it yet. And the link is one of those long links, so I didn't post that. But if you are in Google and you search for Wisconsin Circuit Court Form GN-3130, you will be able to download that form. You can download it in PDF format and take a look at all of the questions that that report is going to ask your child's doctor. And again, that's where I like to start. I don't see the point in filing a petition for guardianship with the court until we know for sure that your child's doctor is on board and agrees that your child will require a guardian. So for my guardianship clients, we always start with that. And then we have a better idea of where we're at when we file the petition. And so once we have the report, we file that along with a petition asking the court to appoint someone, or like I said, possibly both parents, as the guardian of the person and maybe also the guardian of the estate, one or the other, or usually it would be both. Now, once the petition is filed, a number of things have to happen. So your child will be required to be served with the petition. Now, it sounds scary, but it's not scary. So, those of us who work in guardianship, especially with elderly people or people with disabilities, we have process servers who we use who are very, very sensitive to the situation. So, they're going to call you and they're going to come over to your house at a time when you're there and you're going to be there with your child. And then the process server very gently sits down in your house and in very basic terms explains what the petition means to your child, right? But again, those of us who are in this realm, we're not gonna, it's not like you see in the movies, right? Like, oh, you're served if it's a divorce or a lawsuit or something like that. It's a very different situation. So don't get freaked out when you see that your child will need to be served. And then the court immediately, when we file the petition, is going to appoint a guardian ad litem. Now, a guardian ad litem is a separate attorney who is appointed to represent the best interest of your child. And we don't have any control over who that guardian ad litem is. The court is going to choose, based on their random selection process, who the GAL will be for your child. And then once the petition is filed, the guardian ad litem is going to contact you, and he or she is going to usually come to your house and interview you, your spouse, your child, any other siblings or any other individuals who live in the home. And that person, the guardian ad litem, is then going to report to the court, file their report saying whether they agree with the proposal or if for some reason they don't agree. And it's the goal is to protect your child, to make sure that they're in a good situation. I've personally never had a situation where parents who have raised their child from birth are where the guardian ad litem says that it's a bad situation and they don't suggest that. So again, that's not something that you should be concerned about here. It's again very gentle process. GALs work with these situations all the time. And once the petition is filed, the court is also going to schedule a hearing. And it's usually scheduled for about 4 to 6 weeks out after the petition is filed. And that's because we have to obtain service on people. The guardian ad litem has to come and do their study. And then once we, now, oh, and I want to go back for just a minute here. So if the guardian ad litem is interviewing your child, and if your child insists, whether it's legitimate or not, that he or she does not need a guardian and they can take care of themselves. So if they object in any way to the guardian ad litem, if they indicate that they're not okay with the situation, then your child is legally entitled to have a third attorney appointed in the proceeding to represent what they want, no matter what that is, whether it's reasonable or not. And so this is where, when we're talking about the guardian ad litem and we're talking about what service means, a conversation with your child in advance becomes important, just because there should be no reason for that third attorney to be appointed by the court to represent your child. So just kind of explaining to your child in advance, okay, this is what's going to happen. This person is going to come interview you and me and your sister and your brother. And this is just to make sure that we can continue to do those things for you that we've been doing. So I just want to give everyone a heads up on that. I haven't had that happen yet, almost a couple times, but just be aware that that is a possibility. And so by the time we show up to the hearing, ideally, what has happened is everybody has been served properly and we have to show evidence to the court. So we have the process server gives us an affidavit of service showing that service has been accomplished. Other people, your heirs at law, the heirs at law of the child, so parents, if they're married, which they wouldn't be, spouses, anybody entitled to service, then it can be served by mail, except for the individual. So we have to file all of those affidavits minutes of service with the court. The guardian ad litem will have filed his or her report with the court in advance. We will have submitted all of the proposed orders, and the court will already have had the doctor's report on file. So ideally, once we get to that court hearing, it takes about 15 minutes. And the judge has a few questions, and the guardian ad litem, as long as we're all on the same page, confirms in court that he or she agrees. And then you get appointed as the guardians. In Dane County, those hearings since COVID have been by Zoom. I don't know, that could change at any time. But again, in the smaller counties, often we still have to appear in person in court. Now, sometimes, especially if we have to appear in person, but even by Zoom, it just doesn't make sense for your child to attend that hearing. And so the guardian ad litem can waive the requirement that your child appear. But sometimes it's good for your child to appear in the hearing, right? And express his or her whatever they want to say in that hearing, and it gives them some agency in the process. So again, that's something that would be decided in advance. And again, I said to contest the guardianship. So if your child is contesting things, that's where things can get a little bit messy. Ultimately, it'll still turn out okay, but it is a possibility. And so once that happens, then even under guardianship, as I mentioned earlier, sometimes your child may retain certain rights. Like I said, maybe they have the right to get a fishing license, the right to make certain decisions, maybe alone or with the assistance of his or her guardian. And ultimately, the court is going to decide which of those boxes are going to be checked on the orders for guardianship of the person and also of the estate. The guardian, of course, must promote independence and, like we talked about before, respect the preferences and dignity of the individual. Now, sometimes it doesn't make sense to pursue guardianship. So very recently, I was talking to somebody and she was wondering if a guardian would be necessary for her child. But her child is already an adult and had been signing things, taking care of herself. She's in an assisted living community with other individuals. She's a young adult. And once we talked through it, it didn't make sense to pursue guardianship, right? But this individual still needs some assistance, right? And with this, I'm going to mention it's a little bit scary. Do they need a guardian? Do they not? In my experience, you as the parents, you already know. And often, almost every single time when the doctor's report comes back, it's consistent with what you already know. You know if they need a guardian or if they don't need a guardian. And I also want to mention sometimes for guardianship, it doesn't have to be forever. Sometimes when your child turns 18, they really do need a guardian, but maybe 5 or 10 years later, they won't need a guardian anymore. And that's okay. There are easy ways to undo the guardian. Well, I say easy, it's a court proceeding. But if it's clear that he or she no longer requires a guardian, we can go back to court and we can undo the guardianship and put them back in charge of themselves. And that's okay too. So again, understand it doesn't have to be permanent. But let's say that we don't need a guardian. We come to that conclusion, or the doctor's report indicates that no guardian is necessary. There are other ways that we can assist that individual. So Wisconsin has what's called supported decision-making agreements, and I do have a link to the Department of Health Services website for this form that you can take a look at. And we're going to talk more about it in a minute. Powers of attorney can be very useful. So I have a client who has a son, he's in a wheelchair, and he can't talk on the phone very well, and it's difficult for him to get around, but he's still his own man. He's fine. He doesn't need a guardian. So we had him come into the office and sign a financial power of attorney. You can even sign with an X. We have witnesses and notaries giving his mom the power to help him set up accounts and communicate with his financial institutions. He signed a healthcare power of attorney, giving his mom the power to schedule his doctor's appointments and help him make decisions. He signed a HIPAA authorization, so his parents, and he wanted his siblings also to be able to call and get information if he's in the hospital or something like that. So those options are always available. For Social Security benefits, you can be appointed as a representative payee. And so that's something you do through the Social Security Administration, so that the Social Security Administration acknowledges that you're the one who who's assisting your child to process all the paperwork and get qualified for the benefits. And then sometimes we have case managers, we have social workers who are really good. There are, again, all sorts of services that are available if you have a child with special needs to assist that child to live their best lives and to remain as independent as possible. And so let's talk first about the supported decision making. And so, and there's a link here. And if you write down that link, or I guess you can't click on it on the screen here, but Wisconsin supported decision-making agreement form, again, through the Department of Health Services, is available to download and take a look at. And you can see when you read the introduction to that form and when you look at the questions, basically the individual, your child, is not giving up their ability to make their own decisions, but they're choosing trusted supporters. So they're saying, I want my mom or my dad to be able to do this for me. I want this person to do this for me, knowing that they could always change their mind. They could always remove that person. It's much less restrictive than guardianship, but it is recognized under Wisconsin law. So that is an option if you have a child who doesn't necessarily require a full-fledged guardianship, but they want to voluntarily give someone the power to help them out. Similar to that is a power of attorney. And this is more comprehensive, and this is what we talked about earlier. And it's another legal document. It's recognized by all financial institutions if it's a financial power of attorney across the country. So it's not specific to Wisconsin. And it allows another person to assist with financial matters if it's a financial power of attorney, or as I mentioned earlier, with their healthcare decisions and scheduling appointments. Of course, this only works if your child has the capacity to sign legal documents. If your child does not have the capacity to sign legal documents, then this is not going to be an option, and we're probably going to need to pursue the guardianship option. But if they can, this can be a great option. Some other alternatives are special needs trusts. I touched on that earlier. So, sometimes your child has assets that they come into, and we need to make sure that we set up a trust so they stay qualified for their benefits. You can be named as the trustee, or if it's a WISPAC trust, you can be named as the advisor on the account so that you're the one responsible for communicating with the organization or with the financial institution that holds the assets. Joint bank accounts, I've seen some parents do this as an alternative. Just be careful with this. So you can add your name, or have your child add your name to the bank account that they use, for example, the bank account where they receive their SSI benefits every month. Again, just be careful. Your child still has the ability to empty the account, to be taken advantage of, and it's also half your account, which could cause trouble when your child is trying to qualify for maybe other types of benefits in the future. So be careful with that. It's not something that I often would recommend. I think it would be a better option, if this is what you're looking for, to have your child name you as a POA on the account, a power of attorney on that specific account, or have the more comprehensive financial power of attorney, which allows you to manage all bank accounts no matter what institution they're at. And again, the community supports and services that we talked about, and like I said, the case management programs if your child has a case manager appointed, which they typically would in your county. So we talked a little bit about this earlier, but again, limited guardianship is only restricting the individual from making certain decisions while they do retain the ability to make other decisions. For example, the young lady I was talking about earlier, we were very concerned in the court, and her doctors were concerned about financial exploitation, but she can still make her healthcare decisions. She can make her doctor's appointments, right? All of that is okay. So we don't need to give full guardianship, but sometimes we do need to give full guardianship. Like I said, if your child is not able to sign legal documents, then we're probably going to want to transfer full authority to the parent or to the parents. But whenever possible, the courts will prefer the limited guardianship so that the individual maintains as many rights as he or she can handle and still protect themselves. Now, when we file the petition for guardianship, often or sometimes what we do is we also name a standby guardian. And so the standby guardian is a pre-planned backup guardian. So let's say that we have both parents who have been raising that child. The child turns 18. We want to appoint mom and dad as the co-guardians. But you have an older adult child who has been an active member, of course, of the family and is very actively involved in caring for the child who has some disabilities. Maybe we want to name that adult child right away from the beginning of the proceeding as the backup guardian, as the standby guardian. If we want to do that, then what that means is when the guardian ad litem is doing his or her study, like we talked about, they're also going to do an equal study with that adult child who you named as the standby guardian to make sure that that person is also an appropriate individual to serve as guardian of the person or the estate. But if we do it all in the beginning, then if something happens to you or something happens to you and your spouse, if you have a spouse, we already have their sibling on board. There doesn't have to be another court proceeding. There just has to be a notice to the court that mom and dad are gone. And then a very simple form giving your adult child the ability to step in immediately and continue to take care of your child. That's not always possible. We don't always have a sibling or somebody who we know right now is able to do that. But if you know you've got somebody, then why not get them on board right from the beginning? So the key takeaways that I want to talk about here is that guardianship, of course, is a serious legal step. And it must be necessary and it must be least restrictive as possible. We talked about the two main types of guardians, the guardian of the person to make care decisions, the guardian of the estate to make financial decisions. But we always want to consider the alternatives before we file that petition in court to make sure that that's something that actually makes sense for you and your family. And so the current decision-making support tools, again, just to summarize here, so release forms, this would be like a HIPAA authorization, giving parents the ability to access medical records. We talked about the supported decision-making agreement. So this is less limiting to more limiting. And again, I really encourage you guys to take a look at that supported decision-making agreement just to see what it says. The representative payee, like we talked about, where you can be appointed by the Social Security Administration to assist your child with Social Security issues. We talked about the financial power of attorney or the medical power of attorney, where they give you the legal authority to make decisions for them. Or, of course, the limited or full guardianship that we talked about. And again, it all depends on your child's particular situation. There's no black and white here. These are shades of gray. But again, I want to go back to what I said in the beginning, is that in my experience, you as parents kind of already know by the time your child is about to turn 18, what might be the most appropriate action at that point in time. And I do want to briefly, I didn't touch on this earlier, mention we can get you appointed, if guardianship is necessary, we can get you appointed as your child's guardian before they turn 18, which is ideal. So if you're considering guardianship, I always recommend to start the process 6 months, about 6 months before your child turns 18, because then we have a chance to get all the paperwork together, all the information together, to make sure you have the doctor's report ready to go, so that by the time we file that petition and schedule the hearing, we can get you appointed a few months before they're 18. Because as soon as your child turns 18, if you're not the guardian, or if you don't have some other way of accessing the information, you might not have access to their medical records. Like I said, you can't make healthcare decisions, you can't help them with anything. So we can avoid that by getting you appointed before they even turn 18, so that there's no interruption. Basically, things will continue to occur the same way that they have been since your child was a young child. I do want to point out some resources that are available here in Wisconsin. If you're curious about the exact legal statutes, the Wisconsin statutes that I've been referring to in this presentation, if you Google Wisconsin statutes, chapter 54, that is the guardianship chapter, right? So that shows, okay, who needs to be served? How do they need to be served? What happens when you file a petition? When is the guardian ad litem appointed? All the things we've been talking about today, these are the specific statutes where they come from, right? The Department of Health Services can be an excellent resource, particularly with many of the forms that we've been talking about. And so you can choose to have an estate planning attorney like myself if your child is going to sign certain powers of attorney, Or if you want the free, very basic forms, if finances are an issue, the Department of Health Services has a healthcare power of attorney. It has a very basic property power of attorney. It has a funeral authorization and other forms that are available at no charge through the DHS website. So something to keep in mind and check out. The ADRC I found, especially here in Dane County, is really good. They have, and I'm sure if you have a child with disabilities, you probably already are aware of that, but they're fantastic. And then the Wisconsin Board for People with Developmental Disabilities is also an excellent resource as well. And then, of course, attorneys like me, local attorneys who specialize in special needs planning. This is not an area where I would go to a general practitioner. Whether it's your estate plan to make sure that your assets are protected for your child with disabilities when you're gone, like special needs trusts, or whether it's acquiring guardianship for your child, you really want to go to an attorney who specializes in special needs planning. You don't want to go to the small town attorney who did your brother's divorce, who does a little, dabbles in a little of everything. And it's just because this is a very specialized area, and you want to make sure things go as smoothly as possible and that you've covered all your bases. All right, at this time, I would like to open it up for any questions that anyone might have. Let's see, Janice, I think I'm going to stop sharing my screen. If I can figure out how to do that. Ah, the button is so small.
Okay. Yeah, does anybody have any
Gotcha.
questions?
There
Everybody's
we go.
on mute,
Yeah.
um, but we can unmute as if you guys have questions, go ahead and jump in.
I have a question.
Yeah.
Eureka, I sent a question on the chat, but maybe you don't see it.
Oh,
So
I'm
it's a,
sorry.
I
I
just
saw
like you
my
to,
screen. I
can
didn't see it.
you explain the difference between protected placement and guardianship?
Sure. So protective placement is a much more extreme measure than guardianship. So protective placement is when you need to um, place somebody against their will in some type of an institution to protect them. And the guardianship is simply naming somebody to make decisions for that individual. So very different. And that's usually for their, it's when they pose a safety risk to themselves or others is typically when we need to pursue protective placement.
Any other questions?
Yes,
Go
Dara,
ahead.
can you hear me?
Yes.
Okay. Um, this is Jen from Jen and Erica.
Yes.
We have a 529 account created for our child. Would that be considered one of her assets?
It is considered one of her assets, and that's where if you're appointed as guardian of the estate, you would be involved in managing that account. You would be able to manage that account for your child. And as far as the setup of 529 plans versus WISPAC trusts, that's more a question for, and I think Janice, who is it who specializes in 529 plans in your network?
I've got actually, well, I can say Missy, Ryan, Stephanie, like they all understand how to navigate through that. And we did a presentation on it on Sunday at our conference. And I'm going to be uploading that presentation with Missy's presentation as soon as the videographer has it ready to go on our websites so that people can watch it at their leisure. But I can always connect you with somebody as well.
Yeah, and that's whether or not it makes sense to set up that account. I don't know. That's more of a financial question. But if you're a guardian, then you would be the guardian of the estate of the individual. Then you have the ability to make those decisions and set up the accounts and determine, or if you're a financial agent under a power of attorney as well, to help determine which assets need to go where. And a lot of that depends on if your child is working.
And I think that's the
Earning.
root of my question is that, I mean, the account already exists and we already do manage it. She's not yet 18. But I'm remembering what you said about assets exceeding the amount in which she would qualify for benefits.
The 2000, and that's where able accounts can be very beneficial in keeping your child under the $2,000 asset limit. And so, of course, you're managing the account because your child is a minor, but that's where once your child turns 18, you would want to determine if guardianship is necessary or if it can be accomplished with a financial power of attorney. But somebody, once your child is officially an adult, when they're 18, obviously would need to manage that account along with everything else.
All right, thank you.
I have a question. This is Erica. I'm trying to turn our video on so we're not so rude, but
You did.
I did. Okay, there we
I
are.
can see you.
Okay, good. So I know you said by the time we get to the physician examination process that, parents usually know if guardianship is needed. And my response in my head was like, I don't know. And so with supported decision making, I've done other webinars to try to understand and figure out where our child falls. But with supported decision making, it seems like the child would have to be willing to talk or engage in relationship with more than just her parents.
Right. Correct. Because she's still making her own decisions. You're there to help, but she's still actively involved in every decision. And so it's much, and again, it's not from a legal standpoint, she can undo it at any time. She can override any decisions that her support people are trying to help her with. She could say, no, I don't like it. I'm going to do this instead. And so that's where it's tricky, right? Because often they need protection.
Yeah, in our situation, our daughter's turning 18 this summer and she's autistic and she does not talk with anyone outside of us and her sister. I mean, she just
So for that situation, I think, and she's, I mean, again, unless if she really needs a guardian, that's certainly an option. But it's the power of attorney that I think would be more just only based on what we've talked very briefly, this brief conversation, a healthcare power of attorney, a HIPAA authorization, and a very comprehensive financial power of attorney may be more effective, right? Because then she can just say, okay, I just want you guys to take care of this. Will you please go set up my account? Will you talk to my doctor? I don't even want to do this. And that gives you the legal authority to take care of it for her. Many people don't know that a healthcare power of attorney can be effective immediately. It doesn't have to be effective only upon incapacity. It's written into the Wisconsin statutes. So in this particular situation, it sounds like we would make it effective right away. So you can make decisions for her. You can, take care of doctor's appointments and everything else. So I'm okay. To be honest, I'm not a huge fan of the supported decision-making approach simply because they still maintain so much control and so much responsibility to make decisions for themselves. And that can be very overwhelming, especially with a child who has special needs when they suddenly turn 18. So based on my experience, I'm not a big fan of that, but that's not to say that it's not a good solution for a lot of people. Just from a legal standpoint, I think it's so much easier when there's a clear decision regarding who's able to do what.
Can I ask a follow-up about POA?
Sure.
Um, you listed health and financial. What about other areas like post-secondary education, potential employment, housing?
So that's where the power of attorney doesn't, I mean, it gives you the ability to sign contracts, it gives you ability to manage the finances to pay, but your child would still be making ultimately their own decisions and about those. So that's where again, do we need the full guardianship or is the POA going to be appropriate? It depends on how much your child actually wants to be involved in this or is capable of being involved in this process. Because a POA can only grant certain powers. They can't give you everything that a guardianship can provide.
I'm more than happy to have a conversation with you ladies offline as well. Because
Yes,
I can
Janice
give you
is
some other
very familiar.
perspectives
Mm.
that you might not be considering, that I've had conversations with other families. We had a different perspective, so more than happy to schedule a time to talk to you a little bit more in depth about this and give you some other perspectives that you may not be thinking about.
that would be great. Thank you.
Anybody else have any more questions? No? Okay. Well, obviously, Erica, you guys registered for this, so I have an email or you have my email. If you want to reach out to me, again, I'm more than happy to schedule a time to share with you a little bit more, maybe answer some of your questions, more of a parent to parent perspective.
Yeah, thank you. That's a great offer.
Sounds
Thank you.
great.
Absolutely. Okay. Well, if nobody else has any questions, I think at this point we can adjourn.
Can I,
Yeah,
can
absolutely.
I ask a question? I think something's wrong with my Zoom here. Let me see here. Okay. Um, so, oh gosh. Okay. It says continue without camera. So I don't know.
It's okay.
I
We
want,
can hear you. We
okay.
can't
I hope
see
you
you, but
don't
we
mind.
can hear you.
So
You're
I'm, I work with an individual in the community, and he's an adult now, and he really needs guardianship. But then we went to APS. APS said that we need support decision making first before we pursue guardianship. But then he's not appropriate for support decision. He has a mind of 5 years old, and he can talk. He joke. He laugh. He works at a mini part-time job. But then I worked with him for about 8 years, and I know he needs a guardian. So where should I put? Do we have to go to APS all the time, or where can we start pursuing guardianship for him?
Um, this is where I would look at based on the circumstances you described. I mean, you could go directly to an attorney, but I think that maybe going through, starting with the ADRC, starting with his caseworker, starting with other resources, I think would probably be a better option. Because once we have an attorney involved and we file the petition and we get the doctor's report, I mean, he's not really involved so much at that point other than the guardian ad litem, interview and things like that. I think you should start with whoever his case manager is and start talking through the options. And sometimes the state will initiate the guardianship on his behalf, and then it's not you who's initiating it. So that's what I would do. It sounds a little, it's not black and white, right? Like I said, shades of
Mm-hmm.
gray here, and it's tricky. And that's where I know often people will push say you should have support, you start with the supported decision making, but that doesn't always work. Like
Mm-hmm.
you're mentioning, that's not always an effective way to protect the individual,
Mm-hmm.
um, which is tricky. And that's again why I'm not necessarily a huge fan of that.
Mm-hmm. Yeah. I don't think it's appropriate for him. I'm the main person that involved with more like a case manager in the program here.
That's
But
okay. You could initiate a petition. You could file a petition for guardianship, as you could be the petitioner and you could start the whole process. But again, I always like to start with the doctor's report to see what the doctor's opinion is on that. And that's where, like I said,
okay.
take a look at that examining physician's report, and then you can see the questions that are relevant here. And
I
then
see.
yeah, take a look at that, start with the physician's report, see what the doctors say, because if his doctor isn't on board with the guardianship, the court and the guardian ad litem won't be either.
Okay. That's a
Yeah.
good idea. Okay. Thank you.
Any more questions? Okay, well, that concludes Guardianship 101. Thank you, Dara. We appreciate your time. And as I mentioned before, if anybody has any questions that they'd like to take offline with me, please feel free to reach out with me directly. That's what I'm here to do, is help support families figure out where to go, who to talk to, and all that other good stuff that we have to continue to navigate as parents of special needs dependents. So thank you all very much and have a wonderful evening.